Joining us now, Stanford law professor Doug Melamed. He was the acting assistant attorney general during the Justice Department's landmark Microsoft antitrust case, which I remember well, quite some time ago. Doug, fast forwarding to today, we're at closing arguments here. What is your sense in terms of what's been presented thus far and what legal theories the government is relying on to potentially prevail?
Well, it's hard to get a sense of a trial if you haven't been in the trial and really studied the record. Certainly the news reports suggest that, not surprisingly, there were documents that looked bad for Google and some statements that looked bad for Google. And of course, as you're just reported, with Google being both representatives of advertising sellers and advertising buyers and owning the largest exchange in which the auctions take place, it looks problematic. But the issue in an antitrust case is whether Google got to that position by some kind of anti-competitive conduct, or whether it got to it by simply building a better mousetrap, as it were, and out-competing their rivals. The government's arguing that there were anti-competitive acquisitions, particularly of DoubleClick, that Google has tied separate products together, and most important, that it engaged in what they call self-preferencing, that it used, for example, configured its ad server, which represents, in effect, website sellers providing advertising opportunities to buyers. It configured it to favor its ad exchange over others. And the question will be whether Google, in fact, did the conduct that was alleged, and if so, whether Google prevails in its argument that, on balance, the kinds of things that the government's complaining about really improve the quality and the safety and security of these auctions for the benefit of both advertisers and website
right.
Advertising
but
sellers.
if you can prove self-preferencing, as you just said, wouldn't that be anti-competitive? I mean, it would seem that it does obviously prevent others from effectively competing.
Well, if they're self-preferencing in ways that are intended to exclude rivals and don't promote quality or better service for the advertising sellers or buyers, that's an anti-competitive act. The law, however, is unsettled in the area of self-preferencing because it gives great deference to firms to deal with other companies when they choose to do so and not if they don't want to choose to do so. And there's a kind of unresolved question of whether implicit in that is the right to say, well, I'll deal with you, but only on certain terms, only with my particular kind of dealing. So I think Google will have some legal arguments, although if self-preferencing is found, it's going to have some difficulty, I think, prevailing.
You know, it's a little deja vu for me because I've covered the EU antitrust cop, Margaret Vestager, and she brought similar charges against Google for abusing its market dominance basically in the ad business. And look, they were talking about a breakup, a $1.5 billion fine. Interestingly, recently that got overturned by a court, and the judge said that the European Union made errors in its assessment of the duration of the advertising contracts, that basically they were sloppy about it. And so Google had a victory. I just wonder if there's any correlation, if they use, between what's happening in the EU on some of these cases and what's happening in the U.S., and if they use that material.
Well, I think what happens in the EU is not directly going to affect what happens in the U.S., but it may shed some light on the underlying facts. The facts might not be as bad once you dig into them in detail as they look, at the kind of newspaper headline level when you report, oh, gee, Google has an algorithm that seems to favor one of its businesses over another.